It is almost unbelievable how divided and contradictory our own government can be. One day you see federal officials dismissing the Second Amendment like it is a minor inconvenience, and the next day, you see the Department of Justice stepping up and putting something in writing that completely changes the conversation. Just a few days ago, an FBI director stood before Americans and refused to defend the Constitution when asked directly about an assault weapons ban. That was a moment of deep disappointment for millions who expect their government to honor the oath they swore. And yet, in a shocking contrast, this week the DOJ officially admitted in a federal court filing that so-called assault weapon bans and magazine bans violate the Second Amendment. The filing was submitted by Harmeet Dhillon, the Assistant Attorney General, second in command at the DOJ. That tells you this is not just another lawyer's opinion. This is the number 2 official at the DOJ putting the department's authority on the line. Her signature makes this move unprecedented. It is historic, it is massive, and it is now part of the legal record at the Third Circuit Court of Appeals. Folks, you and I have been waiting to hear this for years, and now it is in black and white for the courts to see. Think about the significance of that. For decades, politicians and activists have tried to convince Americans that banning rifles or limiting magazine capacity would somehow make communities safer. They label firearms assault weapons without even being able to define what that means in a consistent way. They talk about high-capacity magazines without admitting that what they call high capacity is nothing more than standard equipment for millions of responsible gun owners. Until now, the Department of Justice has almost always been on the wrong side, joining states in defending restrictions that chip away at our rights. But this week, that changed. The government itself finally said on paper what we have been saying for years: bans on commonly owned rifles and standard magazines violate the Second Amendment. No exceptions, no maybe. Just clear recognition that shall not be infringed actually means what it says. It feels good to finally say the DOJ agrees, doesn't it? This moment did not come out of thin air. Remember the Bruen decision of 2022? That case was a turning point because the Supreme Court ruled that any modern restriction on firearms has to be judged against text, history, and tradition. What does that mean in plain English? It means you cannot invent new restrictions based on political fashion or public opinion polls. You have to look at what the Second Amendment said when it was written, how it was understood at the time, and what the historical record shows. If there is no precedent for banning a firearm that is commonly owned and used for lawful purposes, then a modern ban cannot stand. That principle, handed down 3 years ago, is now reshaping Second Amendment cases across the country. And here is where the DOJ's filing becomes so powerful. They acknowledged in their own brief that Americans own between 20 and 30 million AR-15 style rifles. These are not rare or unusual firearms. They are among the most common rifles in the United States, used every single day for sport, defense, and the protection of family and community. Under the Bruen framework, firearms in common use are untouchable by bans. That is why this admission matters so much. It lines up perfectly with the Supreme Court standard, and it shows that even the DOJ cannot ignore the reality that millions of Americans already know. That is a massive shift, and we need to recognize it as the breakthrough it really is. The brief goes further. It cites history directly, pointing to the tradition established by the Militia Act, which required citizens to be armed and supplied with ammunition, powder, and gear to defend themselves and their communities. The language in that law was not written in the past tense, as if it were some relic. It declared that people are supposed to be armed. That tradition is alive, and it cannot be brushed aside by politicians who think banning rifles will solve crime. The DOJ aligning itself with that history, at least in this filing, is a game changer. But the real question is, will the courts actually listen? That is what we need to talk about next. Will the courts actually listen? That is the question hanging in the air right now, because what the DOJ just filed is not a casual comment. It is an official statement placed into the record. The Third Circuit now has before it a brief signed by Harmeet Dhillon, the second highest official at the Department of Justice, declaring that bans on rifles and standard magazines do not withstand the Bruen test. Judges handling the consolidated New Jersey cases cannot dismiss this lightly. For years, citizens were forced to battle state governments while the DOJ lined up against them. This week, that old pattern was broken, and the shift is impossible to ignore. The states most invested in defying the Second Amendment are now in the spotlight. California, New York, New Jersey, Illinois, and Massachusetts have all entrenched themselves behind sweeping prohibitions. California's decades-old assault weapons ban has survived challenge after challenge. New York's SAFE Act imposes some of the strictest controls in the country. Illinois passed the Protect Illinois Communities Act, outlawing widely owned firearms and magazines. Massachusetts keeps revising its statutes to cover more models, pushing restrictions further each year. These states have relied on the assumption that the DOJ would stand with them. That assumption no longer holds. A federal brief now tells them that their bans cannot survive constitutional review. It is not coming from activists or lobbyists. It is the Justice Department itself acknowledging the limits of state power. Illinois provides a clear example. The PICA ban is under active review in the Seventh Circuit, with oral arguments this September. The DOJ's acknowledgment lands directly in the middle of that fight, when the government's own lawyers concede that the Bruen framework leaves no room for banning common rifles. Illinois's defense becomes fragile. The same is true in New Jersey, where litigation over rifles and magazines has dragged on for years. Now, in the very circuit hearing those challenges, the DOJ has inserted its view that such bans cannot stand. And in California, the Duncan v. Bonta saga has already forced the Ninth Circuit to reconsider magazine restrictions. Each of these states faces increasing difficulty maintaining policies that the federal government itself refuses to defend. This development does more than weaken specific cases. It alters the entire balance of the legal battlefield. Courts pay attention to who is speaking. When the DOJ intervenes, it is not just offering one more perspective, it is signaling the position of the federal government's enforcement arm. That authority carries weight in every courtroom. For decades, that weight pressed against gun owners. This week, for the first time, it pressed in favor of the Constitution. That is why attorneys across the country are already seizing on this brief. They can now point to a government admission that supports their arguments rather than undermines them. It is a turning point in how these lawsuits are fought. The implications are enormous. Activist judges may still try to uphold restrictions, but the ground under their feet has shifted. They can no longer rely on the Justice Department to back them. Each decision they make will be scrutinized under a new light, and every departure from Bruen will look even more indefensible when the DOJ itself has recognized that bans on common arms fail. That creates pressure, and pressure shapes outcomes. When federal agencies stand with the text of the Constitution, courts are far less free to treat the Second Amendment as a second-class right. This is why the filing matters so deeply. It is not only about New Jersey or Illinois or even California. It is about a broader signal the Department of Justice is telling the states that the Second Amendment means exactly what it says. That message strengthens every pending case. It emboldens attorneys fighting for freedom, and it narrows the path for those who want to restrict it. Whether the courts heed that message remains to be seen, but the stage has been set, and the consequences will reach far beyond one circuit or one law. The stage has been set, and now we have to look at the momentum building across the courts. The DOJ's filing in New Jersey is not happening in a vacuum. Over the past year, judges have struck down restrictions that once seemed untouchable. Short-barreled rifles, which the government tried to regulate out of existence, were recognized as protected. The outdated tax on silencers was finally repealed, confirming that financial barriers cannot be placed on rights. These rulings, taken together with the DOJ's amicus brief, form a single pattern the courts, and now even the Justice Department, are aligning with the plain text of the Second Amendment. This is not coincidence. It is history unfolding step by step. Momentum matters because legal change is built one ruling at a time. Every decision adds to the weight of precedent until the truth can no longer be denied. By placing its authority on record, the DOJ has reinforced the very foundation of the Bruen framework. Attorneys can now walk into court and point to the government's own words: bans on common rifles and standard magazines fail under the Constitution. That is not opinion. That is the Department of Justice acknowledging reality. And when reality lines up with the rights of the people, momentum becomes unstoppable. This moment forces us to be honest about what these bans were ever about. If the goal were safety, The politicians writing them would admit that AR-15 style rifles and standard magazines are owned by millions and used responsibly every day. They would admit that crime is not driven by these firearms, but by criminals who ignore every law already in place. Instead, they chose to define common tools as contraband. They chose to create new categories of prohibited based on fear and politics. These bans were never about protecting families. They were about consolidating control. The DOJ's filing rips the mask away. When the government's own lawyers acknowledge that these bans lack historical foundation, it exposes what they always were: a tool to limit freedom. That is why what happens next depends on us. Victories in court are fragile if the people do not defend them. Politicians will rewrite bans under new names, hoping no one notices. That is where citizens come in. Whether you live in California, Illinois, or any other state trying to restrict your rights, your voice matters. Call your representatives. Support the lawsuits. Share the facts with neighbors and friends. Do not assume the courts alone will protect you. Rights survive only when people insist they be honored. Every single day. Engagement is not optional. It is the price of liberty. Remember this: the Second Amendment is not a second-class right. It is the backbone of the Bill of Rights. Without it, every other freedom is at risk. The DOJ's brief confirms what the Constitution promised more than 2 centuries ago. But promises are just words unless the people breathe life into them. This is the time to stay vigilant, to stay involved, and to keep pushing forward. Victories only last when citizens refuse to give them up. The government will never keep you safe. It never has, and it never will. The responsibility to defend your family, your community, and your country rests with you. And now, with the DOJ standing alongside the truth of the Second Amendment, you and I are witnessing history. Do not let it pass you by. Carry it forward.